Thank you. Thank you so much for having me. And it was wonderful listening to the other speakers. And it's probably a good thing that I'm last because much of what I'd like to talk about has to do with issues also around judicial productivity, criminal justice reform. Because the subject of my discussion today is what the three criminal law bills that were recently introduced in Parliament, what they seek to promise or what they promise and what is actually delivered. And I think in the spirit of what the speakers earlier have also done, which is to shed light on existing problems in the system, which they were able to sort of analyze and bring forward with data. If these three bills are finally passed as laws, I think that kind of data will also tell us whether they promise to deliver efficiency in the system. But what I will try and do is, and since I have 15 minutes and we're talking about three massive bills that were introduced, which is the Criminal Procedure Code, the Indian Penal Code, and the Indian Evidence Act, which were reintroduced in their new avatars in Parliament only about 28 days ago. They were first made publicly available only 28 days ago. So it's also actually, that itself is a question of public concern, why these bills were not, drafts were not presented to the public anytime before 11th of August. What I will try and do today is confine myself to the very broad kind of argument or broad issues that these bills have raised questions around, both for me as an independent researcher. And I should probably also mention that I'm editor databases at Article 14, which is a media company based in Bangalore. I also did A Decade of Darkness, which was a study into the use of India's sedition law, Section 124A in the IPC. I'm also a research fellow at SOAS University in London, where I started only about a week ago. So here's what the three bills have done. And in fact, before we even get into the bills, there are pre-passage of the bills events that have happened, and there is a post-passage of bills events that took place, which also shed light on the sort of overall promises made by the legislature and the executive in how what we as public are to expect out of these bills. So one is that there was a criminal law reform committee that was set up in 2020 at National Law University, Delhi. There was a lot of criticism at the time that this committee was set up because the committee was not representative of a wide range of stakeholders who've been working on criminal law, criminal justice, and criminal law reform for decades. None of them found any place in the committee. They objected to the setting up of the committee. These objections are also made public. The other problem was that the committee did not make drafts publicly available as they were working. They did not give enough time to respondents to even answer the questions that they posed in these drafts. And therefore, there was virtually no engagement with the committee. The proceedings were secret. A lot of opacity sort of shrouded the workings of the committee, which itself is a problem when legislating any new bill. This is before the bills were even introduced. Now, the bills were finally introduced in Parliament on 11th of August. The drafts were never made public. So this is the first time that any of us are really seeing it only 28 days ago. After the bills were introduced, they were referred. This was done again on the last day of Parliament. And so therefore no really debate or discussion was, there was no time for that. After the bills were introduced, they were referred to a standing committee. The standing committee is being given 3 months, which again they have objected to, saying this is not enough time, clearly, to deal with three massive criminal law bills that are at least about probably 800 sections between all of them. Now, of course, this sort of pre-consultative, post-consultative process also sheds light on why is it that there is so much secrecy around bills that have such an important, will have such an important impact on public life as we know it. So this is certainly a question that came to my mind when I was following all of these events. Now, coming to the substance of the bills, I think it's important to first understand, and as the previous speakers have already kind of pointed out in very specific details, what the overall problems with the justice system are. Speed, which is we are not fast enough. which is that there is also an abuse of power in particularly in criminal law, where the police officials and magistrates are often accused of excessive uses of power. The third is, in fact, that the process is the punishment, and this is something we see even in civil law. We also see this very strongly in criminal law, because in criminal law you are deprived of your personal liberty even for one day if you are wrongly sort of accused. And so these three problems around speed, abuse of power, and the process being the punishment is something that has plagued the criminal justice system even before these bills were introduced. Now, what these bills promise, or seek to promise, are that they are a departure from colonial law, that they actually do more by way of protecting vulnerable groups, that they remove many archaic colonial provisions, and therefore they are good for the health of the system. But what actually happens when you kind of read this bill clause by clause is one, and this is again, publicly available sort of critiques around how these bills were drafted, is that they were in all three bills virtually verbatim copies, languages copied from the old bills into the new bills. So that's one. The second is the idea that the new bills are somehow a departure from colonial provisions is again something that when we look at the clauses of the bill, we see that's not true, because the language of these provisions and I will sort of demonstrate in some of these in the IPC, is even vaguer, even broader. Vagueness in statutory language is something that the Supreme Court, again in Shreya Singhal, when it was dealing with the Information Technology Act and striking down 66A, it sort of emphasized really well why vague criminal laws are a problem for all of us. It's a problem because if you do not know what you are accused of, or you do not know whether what you are doing is a crime or not, how are you how is anyone going to know whether you will be arrested or not? One should know what is a crime and what is not a crime. It should not be vague, because vagueness leads to differing interpretations across tiers of government, across courts, as we have seen, which in turn have sort of domino consequences on whether it is backlog, or whether it is efficiency, or whether it is sort of repetition, jurisprudential confusion, all of this that hampers the health of our justice system. So for instance, if I were to look at clause 150, which is the new sedition provision, which is supposedly a departure from the British section 124A, the new provision in fact adds more confusion by saying things like encouraging feelings, having subversive, quote unquote, subversive activities. Now terms like encouraging feelings of secession or encouraging feelings of separatism is something that who is to interpret something like this? In fact, this is exactly what happened with sedition, with section 124A, which is what led to the Supreme Court finally staying that provision. There is an interim stay on section 124A that happened last year, precisely for this reason, precisely because there were public interest petitioners who pointed out to the Supreme Court that this is a provision that is misused because it is vague, because it is overbroad. The problem of misuse is something that also originates, and we have seen this, originates at police stations. In fact, the courts have tried to sort of solve the problem of misuse, as they tried with sedition in Kedarnath Singh, for example, by saying that incitement to violence is the only thing that can be considered when you're sort of interpreting whether something is seditious or not. Again, it didn't sort of matter that Kedarnath Singh already said that, because we saw that the police were anyway sort of arresting people by filing an FIR for offenses like sedition. So this sort of what we call the vice of vagueness in criminal law continues with the new IPC. It has not disappeared. In fact, it has been enhanced. So, for example, Terrorist Act, which is the new clause 111, again, which we have a separate UAPA, an Unlawful Activities Prevention Act. 1967. So for me, the confusion certainly is why this kind of over legislation. Why do we need to have a UAPA? Why do we also then need to have Terrorist Act separately defined? Terrorist Act, which finds a mention in the chapter under offenses on human body, not under offenses against the state. Again, this is an interesting sort of different sort of interesting something for us to think about. Why is terrorism now considered an offense against the human body? What is that conceptualization that the government had while doing this, or the drafters had while doing this? And it is not under offenses against the state. So what does this mean? Is terrorism a crime against the body and not a crime against the state? Because this is something that has other sorts of consequences for all of us. The other sort of moving to the CRPC, for example, these are some of the provisions, of course, in IPC. There are several others, for example, on gender, where the new bill seeks to protect women and children more. But seemingly the only sort of major sort of offense that's been included is gang rape of a woman under 18 years, which is now a crime. Also, the promise to marry by deceitful means is also considered rape. So this is again something that the feminist movement and people who work on sexual violence against women and children also have many criticisms around, the perceived gender neutrality of these provisions in the IPC. But moving on very quickly to some of the questions I had around the CRPC. For instance, the addition in let's say the first information report, which in the old CRPC is section 154, where a police officer, you go to a police officer, you tell them that there is a cognizable offense, they will write it down and record it. Now in the new CRPC bill, what they do is they've added this provision called preliminary inquiry. So what the police officer will do is they will now have a preliminary inquiry to see if an offense has been committed, and then they will register an FIR. There are pros and cons to this approach. And here I'll refer to one judgment of the Supreme Court called Lalita Kumari that actually mandates that FIRs should not be preceded by a preliminary inquiry. However, the context in Lalita Kumari was that a 6-year-old girl was kidnapped. Her father wanted to file an FIR. The police station in Uttar Pradesh, the police station did not, the police officer did not file that FIR. And so the father had to sort of, run between various officials to try and get this FIR registered. And so finally, the Supreme Court said, this is exactly the problem, that where FIRs should be registered, they are not. And where they shouldn't be registered, they are. And therefore, all FIRs are mandatorily registered, no preliminary inquiries to be done. However, in the new CRPC, they've sort of added this preliminary inquiry. So this again is what does this mean for the jurisprudence that has been laid down on this issue? We don't know. Again, one of the advantages, to come back to say offenses like sedition, in fact, a preliminary inquiry would be good, because very often what we found in our data on sedition is that even if you like or tweet or share a post on Facebook or any of the social media platforms, immediately the police will file an FIR against you. No preliminary inquiry is necessary. So of course, here it would certainly be very advantageous that the police does not rush in to criminalize or rather to file an FIR. However, in cases against, say women and children or people or vulnerable groups who are unable to register FIRs, a preliminary inquiry works against them. So this kind of contextual analysis around an FIR is also so important to understand in a country like this, when these kinds of changes are being introduced, because different social groups will experience these reforms very differently. Another provision in the CRPC is again around police custody, which is to me was slightly confusing, because currently police custody can be extended by a magistrate in 15 days at a time. However, the new provision, what it says is it can be extended 15 days at a time in whole or in parts. So of the 60 or 90 days that you are allowed, or rather you can be in detention, after which you will get bail, a magistrate can now sort of extend your detention, perhaps, and this is how I interpret the section, can perhaps increase detention 1 day at a time. And sort of, so this is again very confusing, where earlier they could do in 15 days as a whole. Now they will be able to do it 2 days, half a day, 3 days. So, again, that kind of uncertainty for somebody who's been arrested is even more prevalent in the new bills, which in fact the old CRPC sort of prevented and safeguarded certain kinds of abuses. Another thing that the new CRPC does is also that a magistrate, even if you have not been arrested in connection with an investigation, a magistrate can call on you to provide voice samples, handwriting samples, blood sample, anything to sort of help the police with their investigation. Earlier, you had to be arrested in connection with that investigation. Now you don't have to actually be arrested at all. You could just be someone, they are an interested party or a potential witness that they could call, and they can ask you to come in, or they'll authorize you to come in and give your, sort of body samples or other kinds of samples. So, these are, and, another thing in the CRPC, again, a final point here on, specific provisions is again clause 473, which is that on filing of mercy petitions by death row convicts. Now, what one of the clauses in this says is that no appeal to a court, to any court, shall lie against the order of the president and the manner in which the president has arrived at that decision. This is again very interesting. It's sort of, again, this is something only time will tell us, whether it conflicts with an existing judgment of the Supreme Court in Shatrughan Chauhan that says that the court can look at whether there was sufficient delay in granting mercy to a prisoner on death row, whether there was mental health, whether there were mental health issues, whether there was solitary confinement, certain issues that will that a death row prisoner can then be pardoned. So this is something that the court, there is a judicial review around this, which now the new CRPC sort of, takes away by saying that no appeal shall lie against the mercy order, against the order of a president in a case by a death row convict. So, overall, and if I had to sort of, again, narrow all of this down into what is it that the new bills try to do. Again, one of the things that we see across three bills is the addition of technology. So whether it is in the IPC, in the CRPC, or in the evidence, the new bills, each of them have the insertion of some kind of the definitions of electronic communication, audio-visual. So for example, search and seizures of incriminating evidence can now be recorded on your mobile phone. So there are several provisions in each of these that include technology or the use of technology. Now, again, there are pros and cons to this. So while a witness need not have to travel all the way to court to give evidence can be recorded electronically. There are other things that might be an issue. For example, how is all this to be stored? How is evidence given by witnesses, statements given by everybody, by the accused, recordings of search and seizure? How is all of this to be stored? Where is it to be stored? Particularly in an era where we understand all too well the dangers of deep fakes, photoshopping, anything that can sort of happen to technology. How do we know that all of this very crucial evidence that is now being taken electronically, where is it being stored? How is it being stored? What is the chain of custody here? Because again, here we have forensic labs across India that are not regulated in the way they should be regulated around electronic evidence, the use of electronic communication. So while they are regulated around the collection of medical samples, what about the collection of electronic evidence? This is something, again, these are questions that came to me when I was sort of trying to read all of these bills and see what are some of the overarching issues. And I would sort of conclude by saying, the question is, did we need this kind of overhaul? I think that's the question to ask. Did we need 3 completely new bills to be passed? Could it have been that amendments be made to specific sections, because legislative amendments can be done either by removal of sections or diluting them, reading them down. In this way, piecemeal reform has been done to the CRPC already over, over 180 years. Did we really need entirely new provisions that are already verbatim copied from old laws? We should have had deeper consultations with everybody, with the general public, with legal practitioners, former judges, a whole range of stakeholders who have experienced the criminal justice system as both as victims of it and as people who work in it. None of this was done. So why was this not done? Why is there such an urgency is also the question that came to me. Why such urgency? Why such secrecy? Why such little time given to people to study the provisions of these bills? Why is it again that we have retained overbroad provisions, vague provisions? Why are we repeating the mistakes that in many instances the Supreme Court has already pointed out? That these are not mistakes that the justice system should bear. Why is it that we have not learnt from that? So it seems like what is being said publicly, that this is good for us, that it's a departure from colonial practices, does not appear to be so when you actually read the bills. So I think there are serious concerns around the drafting of the section, the addition of new sections that are overbroad and vague, the over legislating. So, for instance, on organized crime, there is a whole new section again in the IPC, in the new IPC on organized crime. Why do we need that when we have state laws? Again, these are taken from the Gujkoka and the MKOKA and every sort of state that has legislation on organized crime. Similarly, the language in this organized crime section in the new IPC, for example, uses terms like having severe consequences, encouraging feelings. I think the word feelings is again repeated a lot in the IPC, which was already there in the old IPC. So to me, this kind of, what was the purpose of the exercise is really I think the question we should be asking. And is it going to give us what it promises? I think only time will tell. And we have now a winter session coming up in Parliament. Will these bills be passed then? What will the standing committees say about these bills? Will the standing committee's report be something that we can, be made available publicly? And what happens? And I think it's also important for us to remember that this is something that's being done in the backdrop of a general elections coming up in May 2024. So certainly that urgency makes perhaps electoral sense. But the fact is that these three laws have huge impacts on the lives of 1.2 billion people. How are you going to communicate these changes? Not, to every functionary in the criminal justice system. There are 15,000 police stations. How are you going to train everybody to kind of understand these bills? So, there are so many questions just around the dissemination, the communication, the almost reconstitution of the entire system, reinterpretation of provisions, new jurisprudence that has to now come out. It sort of is going to, in my opinion, make things worse, not make things better. So I'll conclude there, and if I'm happy to have questions or have this be a discussion, since again, as I said, it's only been 28 days since all of us even saw these bills being made available publicly. So I'm certain that hopefully in the coming months, far more detailed sort of discussions around particular provisions will be possible. But since today was about a sort of broad overview of the three bills, I hope that what I have said resonates with each one of us here. Thank you so much for having me.